Hey there, Aaron Dunn here from Smarter SMSF. In this video, we're going to be looking at the introduction of a new SMSF legal document, a Fund Members Guardian, a specific clause or condition within our SMSF trust deed that allows you to appoint an individual to help oversee the decisions around the members' superannuation interests. So things like circumstances where an individual becomes incapable, or even in the event of the death of a member. Now, we have built out this fact sheet or guide and include a case study in this that talks very much around the Rule 26, around the appointment of a Fund Members Guardian. The purpose of that Fund Members Guardian to help in the management of the members' superannuation interests, most likely, as I said before, in respect to legal incapacity or upon the death of a member. We also talk about the circumstances where a fund guardian would be appointed, and in particular things like a conditional pension, or where again we want them to oversee decisions alongside that enduring power of attorney. So again, this document enables you to get a stronger understanding of how and why you may put in place a fund members guardian for one or more members of the fund. And I encourage you to go through and actually have a look at this document, and in particular the example and what the role of that guardian would do in that particular instance. So let's now move back to the form and go through what the inputs are in respect to creating this legal document, but more importantly, what the outputted document and resolutions then ultimately look like. So we've got our Smith Family Super Fund here, so Smith SMSF. We've got our fund establishment date here, and then we are obviously looking here at whether the deed may have been amended at some point in time. So we're referencing the most current deed, which of course should incorporate the ability for the fund members guardian to be appointed. We have our corporate trustee. We also therefore select the number of directors, the address, and then we have John and Jane Smith inside this fund as the directors and members inside the SMSF. So that then what we look at is here, who are we applying for the guardian to be appointed for? So in this instance, we're going to have John Smith. Let's say we're trying to mitigate him becoming incapable at some point in the future, and we're wanting to appoint the fund guardian in that particular role. So then we have our member address here, you can see, and we're now moving in the next page to all the questions that we're trying to assess in respect to John as that member. So how many guardians are we going to appoint here? And then we're going to put in that specific name. So if we just say that's going to be me as the guardian here, we put in the specific address of that guardian, and then once we establish all the particulars of that particular member, or of the guardian I should say, we then are looking at the role and activities that fit around what the guardian is going to be able to do and will be allowed to ultimately do. So the first one here is the role of the guardian to commence on the signing of this deed. So if it is, then that's fine. If it's not, well, then we can specify at some other point if we want to have that occur. Then do we want the guardian's role to be terminated on a specific date? If it's yes, then we would put in that date. If it's no, then of course it would carry on. If we want the guardian's role to continue after the death of that appointing member. So do we want to ensure that there is specific circumstances that we want the guardian to oversee even though the member is no longer here? So again, that is a yes or no. And then whether we want to provide the LPR or enduring power of attorney the ability to terminate that role of the guardian, or is the guardian in essence there to sit alongside and help in that decision-making process? So in this instance, we'll say no, because we want them to be able to carry on that role and in theory, be able to support the decisions that that enduring power of attorney or LPR may need to make. Because in many instances, this may be you as the professional being appointed as the fund guardian to assist in many of these tasks. And then the final one here is whether you want them to become a member of the fund. So this here will allow you to simply choose those decisions that could allow, again, for that member or that guardian to be appointed inside the fund. And then what we're looking at here is the decisions that we would like the guardian's prior consent to be provided before the trustee can actually act on specific decisions. So for example, does the trustee need to get the guardian's consent in respect to the withdrawal of benefits, the rollover or transfer of benefits, to make sure that money doesn't disappear, in particular where we think about blended families, to make sure that the benefit stays in the fund because that's what the intention ultimately is. Whether there's any payment or change of benefit or to any of the benefits of the appointing member, to potentially appoint new fund members. So it may have been a decision where you're trying to add additional parties in to try and vote individuals out. So again, you can influence that type of thing. Any decisions around the investments inside the fund, so real property or any or all investment decisions, or make changes to the investment strategy if we've got property, borrowing of money, or any other powers or functions that are conferred by the trustee. And most importantly here, we can look at this decision of the guardian being able to charge. And this, where ordinarily if we have the appointment of that advisor, for example, as a trustee, we can't necessarily have a charge in respect to those specific activities. So this guardian appointment can therefore allow us to be remunerated for those particular professional fees and advice and guidance that we have in that role as the fund member's guardian. So we now can then go through and review the information in respect to that application for fund member's guardian, and then subject to the level of membership that you have. So for our Create Legal, you can then generate this as often as you want. For others, with our Create, Learn, Support, or even if on a pay-as-you-go basis, you would then need to, of course, pay for this particular document. So what I'll do is I'll submit this order. It will now go off and look to automatically generate this, and it should take, in essence, no more than 5 minutes at absolute most for that document to not only email you, but then also sit in your completed orders. So I'm just going to pause the video here, and then I'll come back once that order has been generated and show you the completed document. So you can see right here now, it's sitting in the submitted area as processing. So I'll be back with you in just a moment. Okay, so we've now got our completed order here. You can see the email has come through, and if we go to our submitted area and we refresh that, you can also see here that we can download the document here as well. So what we've got is our deed of appointment of guardian within the Smith SMSF, and we can then see the parties to this appointment, or this deed of appointment of the fund member's guardian. Like I said before, you can also download that document there. So we have in here our recitals in respect to the way in which the fund member's guardian works in respect to Rule 26, and then we have the actual appointment of that fund guardian, and then the terms of that appointment, and ultimately the revocation. So all the elements that we spoke about inside the actual form that we were completing earlier. And we then, of course, can incorporate into here not only the appointment, but then the powers and restrictions, again following what we had instigated inside the form. So any investment decision, the details of paying benefits, the ability to roll over, commute or transfer amounts, and any other exercising of power or function that is ultimately granted by the trustee. And then once we have that, we have our conditions precedent, and then ultimately it is signed off by both the member, being duly witnessed, and the guardian as well. We then have our minutes that then support, of course, that request by the member for that deed of guardian to become a special rule of the fund, the resolution that in essence confirms that the case, and the notification from the trustee back to the member confirming that that deed of appointment of guardian has now become a special rule of the fund. And as I showed you early on, we incorporate in here this guidance note and information around the operation of the fund member's guardian, just to help understand the importance of this document and to allow your client to also feel better informed around the benefit of why you have in place now this fund member's guardian. So if you do have any other questions in respect to the use of the fund member guardian document, please feel free to reach out to us, and we'll be more than happy to have a discussion with you further. Take care. Bye for now.